Hi, everyone. I'm going to give everyone a minute to log in from the waiting room and get the closed captions up and running. All right, so the closed captions are up, but I don't think it's letting people in. Let me see what's going on here. Okay, now it's letting people in. Sorry, everyone. I don't know what went wrong there, but hopefully you're able to get in now. I see the numbers going up, and we've got the closed captions up at the top of the screen. So I'll give everyone a little more time since something went a little wrong there. Okay, well, welcome everyone. Hopefully everyone's able to log in from the waiting room and access the closed captions at the top of the screen if you need them. My name is Christy Baglow. I'm the Director of Statewide Training at Florida Legal Services, and I would like to welcome you to our webinar today, which is Frequently Asked Questions, Estate Planning for Legal Aid Clients. I'm really happy to have Brandon Robinson here. I think I kind of twisted his arm into doing this when we were talking about veteran stuff, but he was so gracious to agree to do this training for us. And it'll be more of an informal type presentation. There's no PowerPoint. Brandon's just going to go through common issues he sees and common issues that we might see with our legal aid clients. And we will definitely take questions during the webinar. And thank you to everyone who submitted questions before the webinar. We've got those already on deck. So Brandon Robinson is an associate at Barnes Walker in Bradenton, and he graduated from Stetson University College of Law in 2015. And this is what he does full time. So I know he has so many stories to tell. The things he sees would probably give us all nightmares, but I really appreciate him being here and sharing his knowledge with us. So welcome, Brandon.
Good afternoon, folks. So when we first start up an estate planning case, first thing you really need to figure out is who is your client, right? There's a big ethical consideration of who made the phone call to you. So a lot of times, you have elderly clients that are in a nursing home or even in the hospital, perhaps, and you'll have one of their children or one of their agents under a power of attorney call to try to set up a consultation or have you go and meet with them. Some attorneys are very strict on that and absolutely will not speak with the children, basically tell them that, hey, you need to have your parent call me to schedule this appointment. I am not quite that strict, but either way, if you do take one of those cases, you need to make sure that the children know up front, I do not represent you. I represent your mother. I'm not going to tell you anything about the estate plan. I'm not going to tell you anything about the representation agreement, et cetera, et cetera. And then a lot of times elderly folks will also come in and will want to have their children sit in the room with them. This I do not allow, at least initially. The Florida Bar does put out a very good publication called Why Am I in the Waiting Room? And we have a stack of those at our front desk. And so when I tell the children you're not allowed to come into the consultation initially, some of them do get upset, and I'll give them a copy of that booklet. Once I confirm with the client what their wishes are, tell them that they may be waiving attorney-client privilege by having other people present, etc. If they are still adamant that they want them to sit in the consultation at that point, sometimes I will allow that to happen. In the initial situation I mentioned where the client is at the hospital or in a nursing home, many times I will go ahead and set the appointment for the consult. I will go down to the facility, and when I first meet with the client, I will tell them, my name is Brandon Robinson. I'm an associate attorney with Barnes Walker. Understood you wanted to do some estate planning. Do you want to talk to me today? If they say no, I say, thank you very much for your time. Turn around and leave immediately. Never go after them again, because we don't want to run into any solicitation problems with the bar. Or if they do say yes, I'll go ahead and sit down with them and do the consultation at that time. One way or the other, to make sure we avoid any carpenter problems, which is the case that used to challenge undue influence during wills and will contests and those sorts of things, I will always make sure I meet with the client by themselves at some point, especially toward the end when we have the documents about ready to go, and make sure that this is what they want to do. These are their wishes. No one is pressuring to make these changes. No one is pressuring them to execute these documents, and make sure that this really does confirm their wishes, and I'll document the file accordingly. Any questions about the ethics of who is your client?
I don't see any questions yet.
Seeing none, we will move along. So the second thing, I see one from Dawn, perhaps.
Okay, I will see if she's got a question.
Hello. I can't tell you how timely this is because I just had a conversation yesterday where I was trying to explain to a client, but I really wasn't even able to talk to the client, that it's her right to waive. Do you have them sign a waiver, a written waiver as to the third party being present, or you discussing it with a third party in regards to the estate planning? My case is a divorce case, and there's a very adamant son and his girlfriend that feel that they have to be present for the discussions.
Mm-hmm. I generally do not get a written waiver. I just document my file appropriately. That way, if I'm ever called to testify, I can pretty well know whether or not I can defend it on client confidentiality grounds. The only time I do get a written waiver, and it's part of my representation agreement, is when I am representing a husband and wife jointly doing a joint estate plan. I get one for them acknowledging that there is joint representation, that there, I will not allow any conflict or any secrets between the two of them. And if anyone wants me to keep a secret, I'll be withdrawing from representation. The other one will know why. That is really the only time we normally get a signed waiver of that. But it would not be a bad idea to do so. That way you do have it documented that they acknowledge there is an attorney-client privilege and they're voluntarily waiving that so that other parties can be present during the consultation.
I don't think in this case, I think that in this case, the son and the girlfriend think that they're helping. I just don't think they understand the ramifications of it. And given the forcefulness of their conversation yesterday, I think probably getting it in writing is a better.
Yes, ma'am. And that's generally a very big red flag for us. I mean, it's one thing to want to come in and help out your parent. It's another thing to demand that you be allowed in there. We have had a few of those. And if they're absolutely just going to demand to be in there, we won't take the case. I'll ask them to leave. I mean, pretty much, you have to CYA yourself. You know what your obligations are. So you do have to meet those. Many times in that situation, what I will do is meet with the client initially, go through the consultation, make sure, lay out what their plan is going to be. And then at the end, I will bring in everyone to kind of go over a very general overview of, okay, here's the plan your mother's going to put in place. Here's what's going to happen. And pretty much just leave it at that. But if they are absolutely adamant that they're going to be in there, you may not want to take that case.
That's great advice. And I'll see if I can dig up a sample waiver. I know I used to have one when I worked with veterans, because oftentimes the veterans' wives are the ones who keep track of all the paperwork and know what's happening with those cases. So I'm sure you could adjust it to fit these types of cases. And I'm also going to find a link to that "Why am I in the waiting room" that you mentioned. I think that would be really helpful for everyone. So I'll try to put it in the chat, and if not, I'll send it out afterwards.
So the second thing that we run into is, does your client have capacity, right? Do they have testamentary capacity to execute a will? Do they have the capacity contract to execute a durable power of attorney? And a lot of times this can be kind of difficult to figure out. Luckily, I was an EMS for a number of years, so I learned how to do various capacity assessments on the fly. But, most attorneys are not trained psychologists. We are not psychiatrists. This is not what we normally do. So you do have to do that kind of through just experience, asking them general questions. And that's normally what I do, especially with my very advanced age clients. I'll bring in and just kind of have a little chat with them for about 10 minutes, about the weather, politics, sports, whatever kind of recent events have been going on, to see if they've been keeping up with those sorts of things. Generally you're looking to make sure that they're oriented to at least person, place, and time. They can tell you who they are, where they are, what day it is, and what's happening around them. With testamentary capacity specifically, they need to be able to have a general idea of what their assets are, who the natural objects of their bounty would be, i.e. who would inherit if they did not have a will, and then of course be able to express who they actually want to get their stuff. Contractual capacity is a little bit tougher than that, right? So they have to be able to understand and implement the terms of the contract and a power of attorney. Most power of attorney, some of them can be very long and very complex, and whoever the client is needs to be able to understand and repeat back to you what certain sections of that power of attorney means. So there is a split of authority between different attorneys as to whether or not you should document your file if you need to do a capacity assessment. Some attorneys believe that if you document the file with a capacity assessment, it kind of shows that you were worried about this particular client. Other ones believe it's a good thing to go ahead and do it. That way you can show, well, I did a full-on capacity assessment and I thought that they had capacity. So various tools that you can use to do capacity assessments are the MiniMental status exam, as well as the Montreal cognitive assessment. Both of these are pretty easy to do, and I'm going to show you examples of those. That did not work. Hold on one second. Let me see if I can get it pulled up.
I can see it. It's just not quite full screen yet.
Well, hopefully you're able to see all this over here, folks. But if you do go to Google and you just put in Google MiniMental status exam, this is normally the first web page that'll come up. It's heartandstroke.ca. It has the MiniMental status exam, which is this first page here, as well as the Montreal cognitive assessment, which is pages 3 and 4. We are not psychologists. We are not trained to administer nor interpret these tests, but they can give you a general idea of how your client is doing mentally. So they're not very difficult to give. It's, spell world backwards, count backwards from 100 by 7. I'm going to name 3 objects, repeat those back to me. 5 minutes from now, I'm going to ask you those objects again. Are you able to repeat those back to me? And the scoring system is pretty simple, tells you how to do it. And then it gives you at the end of those what those scores mean. So, if someone, I believe the top score on top score of 30 on the MiniMental, anything 25 and above, generally you're going to be okay. If they're scoring somewhere in the 11 range, you may very well have some problems. So that is one or two tools that you can use if you need to get a solid idea of if your client has capacity or if you're at all worried about it. You can administer one of these tests. Keep it in your file just to show, hey, this is the one that they did. This is how they scored on it. So I believe that they had capacity. Any questions about any of that, folks?
We do have one question, and I posted the link to the MiniMental status exam and also the ABA brochure about why am I in the waiting room. So let me just get over to the questions again.
So I see. How do you tell your client you're unable to help because you doubt their mental capacity? That is a very difficult conversation to have, but it is sometimes one that you have to have. And you just tell them, look, unfortunately, I'm not going to be able to do these documents for you because I don't believe that you have the requisite capacity to do so. With a will, testamentary capacity is kind of a low bar. But especially with the power of attorney and the more complex documents, that is frequently the conversation. Many times, though, you won't have to tell a client that directly. It's more often than not their kids or their agent under a power of attorney that's asked you to go do some work. Like I said, go meet with mom at the hospital, see if she wants to get her documents updated. Then when you meet with her at the hospital, you realize there's no way she can update her documents. She doesn't have the capacity to do so. Then you just have to tell the kids, look, I'm sorry, we're not going to be able to do any documents at this time. Your mother doesn't have the requisite capacity to execute new documents. Generally speaking, at that point, it's for a power of attorney or a destination healthcare surrogate matter. And so that ends up rolling over into a guardianship, which is unfortunate. But if they don't have capacity, they don't have capacity. And I'm definitely not putting my law license on the line to execute documents for someone that obviously does not have capacity.
Brandon, I thought this might be a good point to go over the importance of meeting with clients in person. I know you and I spoke about that while planning this, so I thought this would be a good place to insert that advice.
Indeed. So, especially during plague times that we are currently in, it can be very difficult to meet with clients in person, especially if they're at an institutional facility. So I have done a lot of consultations via phone. I've done a lot of consultations via Zoom. However, at some point, before I allow those documents to be executed, I will meet with that person, with that client in person. Normally it is at the document execution appointment, right? Because you have to have 2 witnesses and a notary anyway. We provide that at our office. So we bring them in. I meet with them in person that time, kind of do one final assessment, go over their documents, make sure they understand everything, and then execute them. Where it is very important in a somewhat related matter is in guardianship cases. I serve as the court-appointed attorney on a lot of guardianship cases, and I absolutely demand to meet with my proposed ward in person. And facilities, even the ones that are under lockdown now, have to let you in because you have a court order saying you are to make this person immediately available to me. With the estate planning clients, it has been more difficult. Matter of fact, I have 2 right now that are in facilities that I cannot get into to get their documents executed. So how we're doing about that, these are generally clients I've done work for before. So I already know them. I know their situation, know they have capacity and all of that. But I've been working with the social workers at the various facilities to actually get the documents executed. And we have had some luck there. Of course, it depends on facility to facility, social worker to social worker, and what the rules of the governing corporation are. Some of them will not allow their nurses and staff to serve as witnesses on any legal documents, no matter what. Many others just really don't care. So that is kind of one small workaround. But yes, I believe it is crucially important to meet with all of your clients in person at least one time before you allow documents with your name on it to go out and be executed.
All right, that's it for questions at this point.
All right, so we're going to start going into what we call the general estate planning package, which consists of a living will, a designation of healthcare surrogate, a durable power of attorney, and a last will and testament. First up, of course, is a living will. And a living will sets forth your end-of-life care decisions in the event that you have an irreversible end-stage condition, a terminable condition, or that you are in a persistent vegetative state. There is a form for the living will under Florida statutes. So if this is a fairly simple client that doesn't have a lot of very odd wishes concerning their end of life care decisions, I suggest you use the form straight out of the statute because the Florida legislature has already said that this is a good and acceptable form. So you can just cut and paste this into Word and fill in the blanks, folks. And it is 765.303. The only change we typically make in that is we ask what we call the Terry Schiavo question is, in the event your physician determines that fluids and nutrition will provide no better prospect of recovery and no comfort to you, may your physician withhold fluids and nutrition to hasten the process of dying? If they answer yes, and most people do these days, we do include a specific paragraph in there stating that physician is specifically authorized to withhold fluids and nutrition under those circumstances. Next up is the designation of healthcare surrogate. And of course, this is where you designate someone to make healthcare decisions for you in the event you're unable to make them for yourself. This one has two versions. You can make it where it is effective immediately, which is most often what we do at our office. That way the named surrogate can go ahead and talk to the client's doctors, become familiar with their medical records, and become familiar with their medical needs before they're called upon to make a split-second decision regarding medical care. The other version, which some people are more comfortable with, is more like what a springing power of attorney used to be like. It only comes into full force and effect when two doctors certify that this person is no longer able to make medical decisions for themselves. Again, there is a form in the statutes, 765.203, that is the suggested form for a designation of healthcare surrogate. So again, in a fairly simple estate planning context, I would just use the statutory form because you know it's going to be acceptable. There is one for minor children as well, which is 765.2038. That is very helpful in mixed family situations, especially with step parents. I am a step parent myself, and I had one of these for all of my step kids because, you know, if the primary parent is working, the other biological parent is out of state, and the step parent has the care, custody, control of the minor children, something happens to them, they have to take them to the hospital, they're going to need some form of legal authority to make decisions for that child. So we do recommend that you get a designation of healthcare surrogate for a minor, and again, use the suggested form that's in the statutes. The next one is one of the more terrifying documents for us, which is a durable power of attorney, whereby you appoint someone to handle your financial matters for you. In Florida, all durable power of attorneys are effective when signed now. So we always caution the client that whoever they name as their agent could take the document the very day they sign it, go down to the bank and empty out the bank account. Of course, there would be legal recourse against the agent for doing so, breach of fiduciary duty, civil theft, etc., but it could happen. So we always caution the client against that. We do tell them it needs to be someone that they trust implicitly and that is preferably good with managing money. You do not want someone with a 400 credit score out there handling your finances. Sometimes clients do not want their durable power of attorney to be effective immediately. So we have often done an escrow agreement where we hold the original. We state in the power of attorney itself, only the original is valid, copies are no good. And we hold on to the original in our will safes here until we receive evidence that the person has gone missing, that they are incapacitated, and we receive doctor's notes, or the client contacts us and tells us to release that power of attorney to other individuals. We do that for other documents as well, but it's usually the power of attorney that the people want held until it's actually needed. We do that often, but I always caution those clients as well. If you do not trust the person to handle your finances and whatnot for you while you have capacity to monitor them and see what's going on, do you really trust them to handle your finances for you when you don't have capacity and can't see what's going on? So that, that's a decision they're going to have to make. And we always, aside from one agent under the healthcare surrogate and power of attorney, we always recommend a minimum of one backup. Two are preferable because we try to make the documents last as long as possible. So one of the other big issues to worry about in the power of attorney are what are called the superpowers. Our special powers as designated by the Florida legislature, and those are found in chapter 709.2202. As you can see, it's a fairly decently long list. We also use, let's kick this over here real quick. This is the This is the special powers as they appear in our actual power of attorney. And so as you see, just the special powers section takes up about 5 pages if they're all included in there. So what are these special powers? They include the power to make gifts, which generally include to the agent. So there is some self-dealing that can be authorized. To engage in tax planning, long-term care planning with a spouse if you're doing it for a married couple, make gifts specifically to qualify for public benefits, enter into caregiver agreements, create and modify trust, create and change rights of survivorship, beneficiary designations, qualified plan elections and waivers like 401ks and IRAs, take statutory elections and renunciations, such as the homestead tax exemption, waive rights to be a beneficiary of a joint survivor annuity, disclaim property, obtain confidential legal information, and one that we recently put in there kind of as a fix until the glitch bill goes through, is to petition for injunction for protection against a vulnerable adult. When that statute came out, an agent under a power of attorney was not listed as one of the folks that are authorized under the statute to petition for injunction for protection against a vulnerable adult. So we added this section in there in the hopes that should that situation arise again in the future, the court would allow the agent under the power of attorney to file that petition for an injunction based upon the specific power granted in the power of attorney. Has it been tested yet? I understand there is a glitch bill pending in the legislature now to add agents under a power of attorney into that statute, but we think it is a good idea. So the biggest thing about the superpowers, as most of you will note, is it allows the people to more or less change the estate plan that you put in place for that client. So there are some we normally do leave in there. Statutory elections and renunciations, caregiver agreements, tax planning, all those sorts of things that would be of a benefit to the client, but where there's not necessarily going to be any self-dealing or not necessarily allow for massive changes of the estate plan. Stuff I normally do not put in there without good reason is changing beneficiary designations, changing rights of survivorship, and those sorts of things. As far as executing these documents, a designation of healthcare surrogate, living will, and durable power of attorney can be executed with one witness and a notary. The notary can serve as the second witness and also take the acknowledgement of the document. We do not like to do it that way, but many times, especially when we have to go off-site or to these facilities, they only let so many of us in. So I only take one paralegal. She serves as a witness. I serve as a second witness and also take the acknowledgement as the notary public. This is not the case, however, with the last will and testament. With the last will and testament, you definitely need two disinterested witnesses as well as a notary public in order for it to be self-proved. If you're not worried about it being self-proved, just any two witnesses will do. One thing to be careful about with those witnesses is they all need to be disinterested witnesses. With the designation of healthcare surrogate specifically, it states in there that they are not blood related to the principal, etc. So we try to get as many disinterested witnesses as possible. Normally, of course, here at the firm, we always use our paralegals, but if you are having to go off site, make sure these are not relatives of these folks, that they are not people named in the estate plan, that they have no interest in the documents whatsoever. Any questions about any of that so far?
No questions at the moment.
Seeing none, we will move right along. So of course, what most people come in to see us for is for a last will and testament. They want to set out their estate plan to make sure that their children get as much of their stuff as possible. They want to make sure the government gets as little as possible, and which all makes perfectly good sense. Again, witnesses are the most important, two disinterested witnesses and a notary public. Special considerations to consider for a will. If people are on their second and third marriages, you need to identify family members very particularly in the will itself, who are biological children, who are adopted children, who are stepchildren, etc. If you are leaving someone out of the will, back in the day, a lot of people used to leave folks $1 kind of to thumb their nose at them, I guess you would say. That is a terrible idea, because then they are considered a specific bequest and they are to receive notice. They have to get copies of the wills and receive notice throughout the probate process. Generally, we tell people if you're going to cut them out, just cut them out entirely, because currently under Florida law, if you have a provision in there that says I specifically and intentionally make no provision for my son, Steve is no longer considered a beneficiary of the estate and does not get any notices of the probate, doesn't really have an opportunity to object to the will or any of that. So if they're going to cut somebody out, make sure you put in a specific exclusion article in there. Other things to take into account, of course, you have to advise the clients, especially married ones, about homestead and the descent thereof. Especially if they are married, they probably want their house to go to their kids, not necessarily their new spouse, but that cannot be done as long as they're married. Sometimes some spouses will sign off and waive the homestead provisions, and there are some new statutes that came out last year to allow you to do that via deed and via some other documents, and that is always an option. But again, you need to counsel your clients regardless of what they put in their will. Their surviving spouse is going to be entitled to certain things: a life estate and or a 1/2 interest in the homestead property, an elective share equal to 30% of the gross estate, as well as a family allowance up to $18,000 gross, as well as exempt property, which is up to $20,000 of household furniture, furnishings, and appliances, as well as up to 2 motor vehicles. Other than that, really, is just counseling your client on who it is that they want to carry out the terms of their will, so who they want to appoint as their personal representative. I do tell them that it is a very trying job, so I suggest that they appoint someone that's going to be able to do it. You know, if it's someone working 60 hours a week, they're not going to have the time to be a personal representative, really. Many times we do run into situations where no one has anyone local to serve as personal representative. Of course, in Florida, to be qualified to serve as personal representative, you either have to be a Florida resident and over the age of 18 and cannot be a convicted felon, or you have to be blood related to the decedent or married to a blood relative of the decedent. So a brother-in-law works just fine, a cousin works just fine, but you know, some friend of yours that lives in New York, that's not going to fly. So again, you do have to make sure that they pick someone that's going to be eligible to serve, as well as that is actually going to be willing and able to serve. I do see we have a question come in. Do you have to specifically name all children beneficiaries? Their provision allow you to include all living and future children. Yes, you can include pretermitted children in a last will and testament. You just need to identify that either in the family section or in the residuary clause itself or in any specific bequest. So you can name all then living children. You can say all the children who survive me, including any afterborn heirs, etc. So yes, you can name afterborn heirs in there, and you can do class gifts. So you do not necessarily have to say, I give 10% to this child, 10% to that child. You can just say, I give the rest, residue, and remainder of my estate to all of my children in equal shares per stirpes, and that works just fine. Any other questions or concerns about a last will and testament?
I don't see any others.
All righty. So now I'm going to get into trust, good, the bad, and the ugly. I very frequently have clients come in and tell me that they want a revocable trust. If that is the case, your first question should always be why? Because more often than not, they're going to say, well, either a bunch of my friends have trust and they said it's a good idea, or I want to avoid probate. That is the number one reason I hear is probate avoidance by doing a revocable trust, which is a perfectly good reason to do so, but I generally don't recommend it. Quite honestly, I am an anti-trust attorney. There are trusts that are very useful in specific situations, but more often than not, they are more trouble than they are worth. Reasons trusts are good. If the client owns real property in more than one state, a revocable trust is a very good way to manage that property so that you do not have to do probates in multiple states. If they have special needs beneficiaries, if they want to take care of pets or something along those lines for a significant period of time after their death, if they have special classes of property, such as class 3 firearms that are better held in a trust, then a trust is a perfectly good mechanism to handle those assets. However, if the sole reason to do a trust is probate avoidance, I generally counsel against it because there are much easier and much cheaper ways of avoiding probate than having a revocable trust. The main reason I do not recommend a trust, one, is expensive on the front end. Here at my firm, we charge a minimum of $1,750 for a revocable trust, which includes a pour over will. For those of you not familiar with it, anytime you do a revocable trust, you should have a pour over will that states the rest, residue, and remainder of the estate pours over into the revocable trust. That way, any assets that are forgotten about and not titled into the name of the trust do eventually end up in the trust through the probate process, so that they can then be distributed to the ultimate beneficiaries. However, again, it is very expensive on the front end. And invariably, it's never done exactly correctly. If all of the assets do not make it into trust ownership, then there's going to end up being a probate anyway. As I just mentioned, you'll have to use a pour over will, but there will still be a probate to get those last few hanging assets into the trust. And then once the probate is completed, you'll have to turn around and do a trust administration, which causes additional time in getting the assets to the ultimate beneficiaries, as well as an additional cost. A probate is 3% of the gross estate, or attorney fees and personal representatives fees for a probate administration. A trust administration is 2.25% of the gross trust estate. So if I have to do a probate and charge 3% against those assets, then it goes to the trust. I turn around, do a trust administration, charge an additional 2.25%. Now we've basically doubled the fees as well as the time that it takes to get those assets to the ultimate beneficiaries. So additionally, there are certain assets that you do not want a trust to own. Typically, we don't recommend that people put motor vehicles in trust because for some reason it makes their car insurance premiums go very high. We do not recommend that they put homestead or tenants by the entirety's property into a trust because there are various cases out there that say it may lose its homestead character as well as the creditor protections that tenants by the entirety's property allows. So without being able to put those assets into the trust, it's almost certain there's going to have to be at least a small probate done, perhaps through a summary administration, and then a trust administration on the back end. So ways to avoid probate without doing a revocable trust, and especially for folks that have, what we call normal people. They have a house, a car, couple bank accounts, maybe a retirement account, and that's it. Ways you can avoid probate without doing a trust are jointly titling assets or setting up beneficiary designations for those assets. You can do that at most bank accounts. You can jointly title vehicles in Florida, I know for sure. As far as the real property goes, you can do an enhanced life estate deed. We are one of the handful of states that allow you to do that. Beautiful thing about an enhanced life estate deed is that it allows the grantor, they give the property from themselves as an individual to themselves for life with a revocable remainder interest to who they want to ultimately end up with the property. That revocable remainder interest allows them to treat the property as if they own it, fee simple, absolute. They can rent it, mortgage it, sell it, do whatever they want to do with it, never have to get permission from anyone to do so. But as long as that deed is still in full force and effect, when that person passes away, all we have to do is record a death certificate and a couple of various affidavits into the land records, and title to that property will automatically transfer to the remainderman. Downsides to an enhanced life estate deed, there are, of course, a few recording costs early on. Typically, doc stamps are minimum. They're only 70 cents because it is a revocable remainder interest. However, doc stamps will come due when the grantor passes away. So it's like a delayed doc stamp, if you will. But again, I typically cancel the clients. It's still going to be cheaper to pay the doc stamps than it would be to pay for a probate. I did have a question come through prior to that. Do we need to advise people based upon on the step up in basis? And I typically do tell the clients about that if their children weren't to inherit the property, they would receive a step up in basis and therefore have to pay less capital gains when it is sold, etc. However, most clients just want to avoid probate outright anyway. They don't want to pay the fees. They want their kids to be able to get the property quickly. So they're more than comfortable allowing the children to take the property at whatever basis they had it at, and then let the kids pay any capital gains tax if there is any. Really depends on how long the property's been owned as well. Any questions about any of that stuff?
We do have some questions, and you know what I forgot when Zoom didn't let people in? I forgot to launch the poll at the beginning.
Yes.
We'll get to the questions. Someone would like you to discuss Medicaid qualifying trusts and Miller trusts, if you have knowledge about that.
Okay.
You guys are being rough on him.
I purposefully do not do Medicaid planning because it's a very complex area that is ever changing. And so I normally refer that business out to various very good Medicaid planning attorneys in my area. However, yes, generally, when you're looking at a Medicaid qualifying trust, most of the time we're doing what's called a qualified income trust. And that's where someone is receiving more income than they should to be able to qualify for Medicaid. So we do an irrevocable qualified income trust where a portion of that income is diverted to this trust every month so that the person goes below the income guidelines for Medicaid. Therefore, they're able to qualify for Medicaid and receive Medicaid benefits for long-term care, whatever the case may be. That qualified income trust does have to have some special provisions in it. Generally, anything that is left in there is to be paid back to Medicaid as part of the Medicaid claims process through a probate process, et cetera. As far as where to find a template, Google is your best friend. If you have access to the National Academy of Elder Law Attorneys or the Academy of Florida Elder Law Attorneys, they have a wonderful listserv. You can ask folks on there and get templates from them. I do have some templates, so if you'd like to send me a private email, I will send you what I have that you can try to use. But again, that's really not my area of expertise, and you do need to be careful and make sure that you jot all the P's and Q's, cross your T's and dot your I's, because Medicaid is very strict on reviewing those trusts, and occasionally even a qualified trust will be disallowed by Medicaid, and you'll have to appeal it and whatnot and show the hearing officer that you did meet all the various requirements set forth in Florida or in federal law. What would you recommend for a client who is self-employed and a sole member of an LLC? So you do run into this a lot, especially with small business owners. They have a sole member LLC, or they're in a form of partnership or a LLC with 2 or 3 members. Generally, any business interest such as an LLC or an incorporated entity, what happens to that property when someone passes away is governed by the operating agreement. A lot of these companies don't even have an operating agreement. So I would recommend that you ask your client, does he have one? If so, he needs to review it. If not, he needs to put one together and determine what's going to happen there. I would also recommend that he think about adding additional members to the LLC now, even if it is a small percentage of the company, if you will, 1 or 2% now. That way, when something does happen to him, they can continue on with that business. If the sole member of an LLC passes away and there are no new members, LLC is pretty much done. So they do need to add some additional members on there, or make it very clear what happens to that member's interest when they pass away. And again, a lot of that is governed by the operating agreement itself of the incorporated company. Is the revocable enhanced? Yes, an enhanced life estate deed is the same thing as a Lady Bird deed. It was called a Lady Bird deed because they used Lady Bird Johnson as the template when they initially put out the example for how this would work. So that's why it kind of got the name Lady Bird deed, but the technical and legal name is an enhanced life estate deed. Okay, another question. Are wills sufficient for couples who have no children in common, but have adult children from prior marriages, and they want home, etc., to go equally to all? If one party passes before the other, the remaining party can then change the beneficiaries. What is best in these situations? So yes, that's a problem we run into quite frequently. People on their 3rd and 4th marriages, they have, his kids, her kids, and their kids. So those do take some very special planning. A lot of times what we do, because in that exact situation, the surviving spouse can always change their estate plan at their leisure. So if they're worried about that happening in the future, sometimes we will recommend trust in that situation. Other times we will recommend an agreement to maintain wills and beneficiary designations between the spouses. And so we write up an agreement that says you will maintain the following terms in your estate plan permanently, as well as your beneficiary designations. We're doing reciprocal estate plans basically, and you both agree that you're going to follow these estate plans. And the only way they can be changed is if both of you sign off on that change. It is a contract, so you do have to advise both parties to obtain independent legal counsel, et cetera, to review said contract. Ours runs about 6 pages, I believe, by the time we put all the various terms in there, talk about what property is excluded from the agreement, because sometimes you can exclude a specific IRA or a beneficiary account, for instance. But once that agreement is entered, it's witnessed, it's notarized, it's official. We recommend that the clients distribute that amongst all of their children, because by the time, one of the parties passes away, they're not going to be able the ones to enforce it. It's going to have to be the kids or the named beneficiaries under the agreement that would have to step up to enforce that in a probate action or a will contest matter.
I'm so glad you're sharing all this information with us today. It's so helpful. We did have a couple questions in the chat, but I'll save those for the end so you can get through everything.
Okay, well, I'm going to address a few of the questions that came in yesterday. Do we need to counsel our clients about gift taxes when one relative gives an inherited interest to another? I am assuming you're talking about disclaiming property through an inheritance, or you are asking, if there's an agreement amongst beneficiaries that they're just going to give their inherited stuff. Yes, you should always counsel them about gift taxes. I am not a tax expert. It is right in my representation agreement that I am not a tax expert and do not give tax advice, that they need to retain a CPA to advise them on all tax related matters. However, yes, if you know there's going to be some gift tax because it's over the limit that gift tax is going to be imposed, you do need at least counsel them on that and tell them that they need to take that up with their CPA. I personally, that's about as good tax advice as I'm going to get. Yes, there's probably going to be some estate tax due on this, or gift taxes due on this. You probably won't have to pay them because the exclusion's high, but you do need to file a gift tax return. I suggest you go see your CPA. Okay, another one came in. These are kind of probate related questions, but I'll still go ahead and answer them. How does a spouse elect to claim a 1/2 interest instead of a life estate? This would be dealing with homestead real property. With homestead property, a surviving spouse generally gets a life estate in the property with a remainder interest to the children. However, the surviving spouse can elect to take a 1/2 interest in the property in lieu of a life estate. They have to make that election within 6 months from the date of death. The second part of the question was, can the spouse wait to file a probate case? No, she cannot. That election has to be made with the court within 6 months from the date of death. So you need to get that probate case opened and get that election filed ASAP. What is the difference in tax basis between inheritance and deeds to avoid probate? Do we need to advise our clients about capital gains? I did kind of discuss that briefly earlier. They will, and I could be wrong on this, but I'm pretty sure an enhanced life estate deed does not transfer a step up in basis when the life tenant passes away. They take it the same basis as the original owners took at, whereas a probate does allow for a step up in basis. So there could be a larger capital gain using the enhanced life estate deed or any other deed for that matter, quit claims deeds, etc., versus allowing it to go through probate and be inherited. But again, most clients are comfortable with avoiding probate, avoiding the fees, and not worry so much about the capital gains, because again, a lot of that depends on how old the property is and what the appreciation's been. And it depends on what the market's doing. Right now, the market around my area, at least Manatee and Sarasota County, is booming. I mean, all houses are, I mean, the prices are ridiculous, quite honestly. I keep waiting for the bubble to bust. But, you know, back in 2008, when there were large losses, you really didn't have to worry about capital gains at that point because most people came in a capital loss. And again, the capital gains, especially if there are more than one beneficiary, if you can get it split out amongst 3 or 4 beneficiaries and everyone pays for their smaller portion, it's normally not that big of an issue. Already addressed how to avoid probate for those that don't have much. Joint ownership, beneficiary designations, those are your best bets and your best ways to go for avoiding probate for smaller estates especially. All right, folks, that is just about all I have, unless y'all have any other particular questions you'd like me to answer.
You had one more come in while you were doing the advanced questions. Going back to wills, what should clients do with the original wills once they're executed? Can a husband and wife do joint wills?
That is a great question. Joint wills, no, there are no such thing. There is a joint revocable living trust. So you can do a joint trust, but not a joint will. They do have to have their own individual wills. What do you do with them? Again, some attorneys will keep the originals. We prefer not to, but we will if the client wants us to. I advise the clients to keep them in a safe place along with all of their other important documents. Wherever your homeowner's insurance and life insurance and all of that paperwork is, that's where your estate planning documents need to be. Wherever they put them, what's most important is that their beneficiaries or their named personal representatives know where they are and how to get to them. The one thing that is crucially important, though, is that they do not, under any circumstances, put it in a safe deposit box unless there is a co-owner with keys that can get into that box after that person dies. Because it is a whole process to get a court order to open the safe deposit box just to see if there's a will in there. So please don't tell them to put it in a safe deposit box. I'm begging you. It makes my life hell.
And there's one more part of that question. Can you devise properties out of the country in a Florida will?
Yes. Short, quick answer is yes. I mean, there are things called situs wills. So a lot of times, if we have a lot of UK clients here. So we do have some that have situs wills just to govern their Florida property or specifically their United States property. So it is possible to have different wills covering property in different jurisdictions. But more often than not, your last will and testament is your last will and testament and controls all of your property wherever located. Fortunately, Florida has some of the stricter execution requirements for a will. So if it is self-proved and admitted here in Florida, it will be accepted just about anywhere. By way of example, I have an estate now where there is a bank account in Bulgaria, and I'm having to send a apostille and exemplified copy of the will to Bulgaria, but it will be accepted there once it gets there. So that is one thing to take into account too, is we do have a lot of snowbirds that come in. You always want to make sure that you're reviewing their documents to make sure that they conform with Florida law. Generally, if they were good where they were executed at the time they were executed, they will be accepted here. But many times it's easier just to go ahead and have them updated because a Florida bank teller is not going to know that this is a valid New Jersey durable power of attorney, for instance. So go ahead and having them updated here is never a bad idea. Thing to take a special note of, though, is the last will and testament. Want to make sure it is executed conformity with Florida law because Florida has very strict requirements about admitting wills, especially holographic or handwritten wills. So we want to avoid those. And one thing to take special note of is if they have a revocable trust from a different jurisdiction and then move to Florida and become Florida residents, you need to pay very careful attention to any dispositive provisions of that will that would take effect after death. Many different states allow you just to have no witnesses. I think some states you don't need any witnesses for a trust. Sometimes you can just get it notarized and that's good enough. Florida is not that way. And we have had many cases where people have moved to Florida, had a will from a different jurisdiction, was not executed in conformity with Florida law, and therefore the testamentary aspects of that trust failed because it wasn't executed in conformity with Florida law. So if they are moving jurisdictions, have a trust, you really need to take a look at the testamentary aspects and make sure that that trust is executed in conformity with Florida law. One of the easier ways we do to do that is just to do an amendment, basically restating the trust, changing the situs of the trust to Florida, so it's governed by the Florida Trust Code, and restating the rest of the trust and having that executed in front of 2 witnesses and a notary.
Sounds good. We had a question come in the Q&A box. What about TOD or POD accounts? Are these a good idea?
Yes, that's why I was talking about beneficiary designations or joint ownership. TOD, POD accounts, same thing. Those are beneficiary designations. So a payable and death account, that is a beautiful way to do it. Yes.
My understanding is you kind of have to ask to have that done at the bank. It's not on their standard forms when you're opening an account. Is that right? Like they don't automatically say, hey, do you want to list somebody else?
That is correct. Every bank does have their own forms. So you'd have to call the bank that you want to set it up with and go ahead and do that. But once that is entered, that is a contract with the bank. And any funds in that account will transfer to that TOD or POD beneficiary once a death certificate is presented to the bank and it passes via operation of law, not subject to probate, more importantly, not subject to creditor claims.
It can save a lot of time and heartache, I imagine. Easy way to get that set up. Last question, what happens to the estate if the will is not filed with the probate court?
So under Florida statutes, whoever is in possession of the will has 10 days to file it with the court in the county where the decedent resided 10 days after the decedent died. Now, does that happen regularly? No, most people don't even come to see an attorney till 3 or 4 weeks later. I've never seen a court raise a stink about it because you deposited late. But if someone is in possession of the will and will not deposit it with the court, then you need to send them a demand letter to do so. If they still won't deposit it with the court, then you can get a court order telling them that they need to deposit the original with the court. Sometimes we're into a situation where we cannot locate the original. All we can find is a copy. There are procedures to get a copy admitted as if it was the original, but there are a few different hoops that you have to jump through to do that. Generally, you have to get an affidavit of a disinterested third party stating that this was their will to the best of their knowledge. The testator had no reason to revoke or amend it. A lot of times we get those from the estate planning attorney, especially if that was that person's long time estate planning attorney, and the courts generally will accept those. But yeah, if you have someone that just won't deposit the will, you can get a court order forcing them to do so.
Well, thank you so much for sharing all this information. I know I learned a lot today. I learned why I don't do estates and trusts also. So I'm glad there are people like you who know all the ins and outs. I did want to announce before I forget that the CLE has been approved. The number is 4535. Again, that's 4535, and it's approved for 1 general credit and 1 wills, trust, and estates credit. Thank you so much, Brandon, for doing this today for us. I really appreciate it. I just really appreciate your expertise in spending this time with us. And thank you also to the Public Interest Law section for co-sponsoring this. Have a good day, everybody.
You as well, folks. It was my great honor.
Lots of compliments in the chat box. Hopefully you can see them. Thank you so much. Have a good one, everybody.
Awesome.